Okay, let's unpack this. Today we're diving deep into something absolutely fundamental to how our interconnected world operates, the often unseen architecture that links something as personal as human rights with the immense forces of international finance, trade, and political relations.
Yeah, it's about exploring how these rights, which we often think of as just individual protections, are meant to be woven into the very fabric of global governance.
This deep dive is built entirely on material you've shared with us, derived from academic sources designed to provide a thorough understanding of human rights and the international legal order. And we really want to express our sincere gratitude to the University of London for making these valuable documents available to students like you.
Absolutely, it's fantastic material.
And this deep dive, like others we do, is purely for educational purposes. This particular exploration is brought to you by Sinorbit Academy, Sri Lanka.
That's right.
And for those of you currently preparing for exams on this subject, genuinely, good luck. We hope this detailed exploration helps reinforce the key points and, makes navigating this complex material a little bit easier.
Fingers crossed it helps.
So our mission today is to take these sources, distill their most important insights, trace the evolution of these concepts, and understand the intricate dance between human rights and these powerful international institutions. It's really about giving you a shortcut to being well-informed on this crucial intersection of law, politics, and economics.
That's right. And the material we're working with starts by setting a critical foundation. It argues that international human rights law isn't just some feel-good add-on, it's an essential element of global politics today.
Essential, not optional.
Exactly. And it's fundamentally linked to the emergence of what the source calls an international legal order. Think of it as a cornerstone of the modern global structure.
A cornerstone. Okay, I like that. Not just a decorative piece on the side.
Precisely. And at the most visible level, the primary global responsibility for human rights is assigned to the United Nations. But here's where it gets really interesting and a key takeaway from the source. Human rights aren't meant to be confined just within the UN system.
Right.
They are considered cross-cutting principles.
Cross-cutting principles.
Yeah.
That sounds, well, a bit technical. Can you break down what that actually means in practice? How does that principle work outside the UN bubble?
It's a vital concept, seriously important. It means that other international institutions, even those whose main job isn't human rights-like, think institutions focused primarily on global finance or trade.
Like the IMF or the World Bank.
Exactly. The IMF, the World Bank, the WTO. They should actively consider the human rights impact and implications of their policies and decisions. Their main objectives, whether it's regulating banks or negotiating trade deals, must be implemented in a human rights-sensitive way.
So they can't just ignore human rights just because it's not their primary function listed in their founding treaty.
That's the idea. They have to factor it in.
So an institution like the World Bank, which funds massive development projects, can't just look at the economic feasibility or the return on investment. They have to look at the human picture.
Precisely. The source provides a really powerful example to illustrate this tension, the kind of dilemmas these institutions face all the time. Imagine a developing country, right? They desperately need electricity to power growth, improve lives.
Thanks, Sam.
So they plan to build a large dam and reservoir on a major river. This dam would generate hydroelectricity, cheap, accessible power. Think of the positive impacts.
Okay.
Lights for homes and schools, electricity for hospitals enhancing healthcare, powering local industries creating jobs. These things contribute directly to human rights, like the right to education, health, and work.
Yeah, absolutely. On the surface, it seems like a clear win-win, a project with significant positive human rights outcomes.
Exactly. Sounds great, right? But the conflict arises because to build that dam and create the reservoir, they have to flood a considerable area of land.
Ah, okay.
Yeah.
There's always a catch.
And that area happens to be the ancestral homeland of indigenous tribes. For these communities, that land isn't just, real estate. It's deeply interwoven with their cultural identity, their religious practices, their whole way of life.
So displacing them.
Displacing them has potentially devastating negative human rights impacts. We're talking about their right to culture, their right to practice their religion, maybe even their right to self-determination, if that land connection is fundamental to their identity as a people.
Ah, okay. So you have a project with strong positive human rights impacts. For one group, the broader population getting power, but equally strong, perhaps even existential negative impacts on another group, the indigenous community losing their land and way of life. This is the core dilemma.
You've got it. That's the tension. And let's say this developing country needs external funding, maybe from the World Bank, to build this dam.
Which often happens.
Right. So the critical question for the World Bank, operating under this principle of considering human rights, becomes, do we fund this project? How do we weigh these significant positive impacts against the severe negative ones? Does the potential economic development and improved services for millions outweigh the potential destruction of a specific community's identity and rights?
Wow, that's a tough call.
It is. And this single example perfectly illustrates how these large-scale economic and development decisions are inherently tied to complex human rights trade-offs and dilemmas.
This kind of analysis, looking at human rights within these broader global fixes, the politics, the economics,
Yeah.
is this what the source refers to as the political economy of human rights?
That's the term they use, yes. The source defines it as placing human rights in that political and economic context to understand how they actually operate globally. It's recognizing that whether rights are respected, protected, or violated isn't just a matter of law on the books.
It's about power structures.
Exactly. It's deeply influenced by political power, economic inequality, global market forces,
Right.
the whole picture.
And while individual nations are undeniably the primary duty bearers when it comes to human rights, it's their laws and actions that most directly affect their citizens.
Of course.
The source points out that this deep dive will focus more on the supranational competence of international bodies of law.
Yes, acknowledging that these international legal structures, institutions, norms, they operate at a level above the domestic. They influence states and other actors across borders. This shift in focus is really crucial for understanding the global landscape of human rights today.
Okay, so to truly grasp how this intersection of human rights and international order came about, we probably need a bit of historical perspective.
Hmm.
The source traces the rise of human rights as a key element back to the process of globalization, particularly that traumatic transition after World War II, moving away from colonial empires.
Right. The post-war period saw this massive wave of decolonization. Suddenly, you have a huge increase in the number of independent states.
Many more countries on the map.
Many more. And as states became generally smaller and more numerous, they also became profoundly more interdependent. No state could be an island anymore. They relied heavily on each other for essentials, food, energy, markets, just general economic viability.
And this period also solidified that division we still see today, right? Between the developed and developing countries.
Absolutely. That division became a central feature of the global political economy. And into this new, more interdependent world, powerful supranational agencies were established to manage the global economy.
The big ones: IMF, World Bank.
IMF, World Bank, and later the WTO. The UN, while unique in its universal membership and broad peace and security mandate, operates within this increasingly complex economic context.
And the UN itself, its creation, was a direct response to the horrors of the world wars, wasn't it?
Directly. The source reminds us of important forerunners, like the Permanent Court of Arbitration from the turn of the 20th century and the League of Nations after World War I.
Which famously failed.
Its inability to prevent World War II really made the need for a more robust international body like the UN undeniable.
Leading to the San Francisco meeting in 1945, the signing of the UN Charter. The source quotes U.S. President Roosevelt's vision at the time, seeing the UN as finally ending the old, failed system based on unilateral action, exclusive alliances and sphere of influence, and balances of power. A big hope.
A powerful statement of intent, definitely, but one that immediately faced a fundamental tension with the pre-existing international legal principle of state sovereignty.
Yes, sovereignty.
The sovereign state was absolutely central to the UN Charter, enshrined particularly in Article 2. And importantly, human rights were not initially as prominent or central in the Charter as we might think of them today.
That's a critical historical distinction. The source contrasts this with the pre-WWII international legal position. Before the war, international law largely took the view that how a state treated its own citizens was its own business, an internal affair.
Pretty much. A matter of its sovereign domain. International law only really got involved if a state harmed a foreigner, a national of another state.
So the other state could complain.
Exactly. The state was seen as the injured party in those cases, based on violations of state sovereignty or obligations between states. Individual citizens had virtually no standing, no protection from their own state under international law back then.
So the post-WWII era marked a profound shift. Human rights began their ascent in importance. The source points to the International Military Tribunal at Nuremberg.
Nuremberg, yes. It tried German officials for war crimes and, crucially, for crimes against humanity.
Crimes against humanity. That was new, wasn't it?
It was revolutionary. Now, the source acknowledges the controversy around Nuremberg, the fact that only the defeated powers were tried, despite atrocities committed by others.
Victor's justice, some called it.
That criticism exists. However, the very concept of crime against humanity was groundbreaking. It introduced this notion that there was something inviolate in the human being, something that even a state could not legitimately violate, and that individuals could be held accountable under international law for such acts. That suggests a potential limit on absolute state sovereignty.
But even with Nuremberg, the source emphasizes that the initial mention of human rights in the UN Charter itself, Articles 55 and 56, was still quite limited compared to where we are now.
Very limited. The growth of human rights law since then implies a significant evolution and, implicitly, a greater limitation on state sovereignty over time. It reflects this growing idea that citizens do need protection from their own governance.
And that international bodies might have a role.
Might have a legitimate role or even jurisdiction in matters previously considered exclusively domestic. This tension between state sovereignty and international human rights, it's still a dynamic force today. It hasn't gone away.
No, definitely not. This evolution continued rapidly with the drafting of the Universal Declaration of Human Rights, the UDHR. Creating this document was one of the first major jobs of the new UN.
And they faced a huge challenge. How do you articulate a common set of core beliefs about fundamental rights that could be accepted by nations with vastly different political systems, economic models, cultural values, all that diversity?
How did they square that circle?
Well, the solution was basically to affirm a shared aspiration, a common belief in fundamental rights and freedoms, rather than trying to create an immediate legally binding treaty. That would have been impossible to get agreement on in 1948.
So it was more about setting a standard.
Exactly. This led to the adoption of the UDHR in December 1948. The source quotes the French representative calling it a world milestone, and it really was a benchmark for humanity.
Okay. And the source highlights three absolutely crucial points about the UDHR that we need to understand. What's the first one?
First, and this is key, it is not in itself a legally binding treaty, it's a declaration. A powerful statement of principles, yes. But states weren't ready to sign up to immediate legal obligations back then.
So it sets out a common standard of achievement.
That's the phrase. A common standard of achievement for all peoples and nations, an ideal to strive for.
Okay, so a benchmark, a standard, but not legally enforceable on its own. What's the second crucial point?
The second point is its emphasis on the totality of rights. The UDHR stresses the universality, indivisibility, and interdependence of all human rights.
All of them. Civil, political, economic.
All of them. Civil rights, cultural rights, economic rights, political rights, social rights. They're all interconnected. They form a whole. They shouldn't be disassociated or seen in isolation or ranked in importance.
They stand or fall together in principle. Makes sense. And the third point.
Third, the UDHR was just the beginning. It was foundational, yes, but it needed to be supplemented by later legally binding treaties that would translate these principles into concrete obligations for states.
Ah, so the covenants and other conventions came later to add the legal teeth.
Exactly. This led to key conventions like CIRD, the International Convention on the Elimination of All Forms of Racial Discrimination, CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, and the CRC, the Convention on the Rights of the Child.
In the source notes, this process raises interesting questions about how human rights law evolves. Like, why were specific treaties needed for groups like women or children?
Right. It reflects the changing political landscape and the need to explicitly include those previously marginalized or maybe considered other within the formal legal framework as political priorities shifted.
And this collection of foundational documents, the UDHR, plus the two major legally binding covenants from 1966, the International Covenant on Economic, Social, and Cultural Rights, ICECR, and the International Covenant on Civil and Political Rights, ICCPR. These together are often called what?
That's the International Bill of Rights. A key term to remember, UDHR plus ICCPR plus ICCPR plus ICCPR International Bill of Rights.
Got it. International Bill of Rights. And the source also mentions significant later developments that built on this, right? Like the Vienna Conference in '93.
Yes, the 1993 Vienna Conference on Human Rights was important. It reaffirmed the UDHR and adopted the Vienna Declaration and Program of Action, which really pushed for a more proactive approach from governments.
And more recently.
More recently, the Millennium Declaration in 2000 explicitly linked human rights to development goals, setting concrete targets for things like reducing hunger and poverty, addressing environmental issues, promoting democracy. It shows how the understanding and scope of human rights keep expanding and integrating with other global agendas.
The source also touches on the underlying political vision of the UDHR itself. It suggests it draws on a kind of secular culture to define a version of the good life centered on the individual human being.
Yes, setting a minimum standard for the values that any political community should uphold. Think about the core rights it lists: life, liberty, security of person, an adequate standard of living, owning property, freedom of opinion and expression, freedom of thought, conscience, religion, freedom from torture. These are the bedrock principles.
Okay, so we have this framework, the International Bill of Rights, these core principles, but how do we actually think about or categorize this huge range of rights, especially given the point that they're all interconnected but seem to demand different things from the state?
That's a great question. The source introduces the traditional way of categorizing rights.
Hmm.
The idea of generations. You've probably come across this.
Yes, the generations framework, first, second, third generation. Useful, but maybe too simple.
Useful for seeing a historical development, perhaps, but yes, the source cautions it has significant limitations. Let's quickly recap them, though. First-generation rights are often called the classic liberties.
Civil and political rights.
Exactly. Rights protecting the individual against the state, freedom of speech, fair trial, no torture, developed mainly 18th, 19th centuries, often described as negative rights because they mostly require the state to refrain from interfering.
So the state steps back. Got it. What about the second generation?
These are rights that typically require the state to do something, to take positive action. Think right to food, shelter, education, work.
Economic and social rights.
Known as economic and social rights, yes.
Right.
Focused on ensuring a more fulfilled existence. They gained prominence with socialist movements, welfare states, late 19th, 20th centuries. Primarily positive rights the state needs to act.
Okay, state acts. And the most recent layer, the third generation.
These are often called solidarity rights or group rights. Rights enjoyed collectively, often by peoples rather than just individuals.
Like self-determination.
Self-determination of peoples, minority rights, the right to development itself. These rights explicitly challenge the primary focus on the individual that defines the first two generations. They're strongly linked to anti-colonial struggles and broader political movements from the mid-20th century onwards.
That typology is useful, as you said, for seeing the historical flow and different types of claims rights represent. But the source is pretty clear about its limitations.
Very clear. It strongly cautions against seeing these as totally separate boxes or drawing a strict dichotomy. There are huge overlaps, and they are, as the UDHR stressed, interconnected and interdependent, indivisible.
Can you give that example again? The link between first and second gen.
The classic one is freedom of expression. First gen can be almost meaningless if you lack the right to education. Second gen. Without education, how can you effectively express yourself or even access information to form opinions?
Good point. You need the means to exercise the freedom.
Exactly. The relationship is far more complex, more nuanced than a simple generational divide suggests.
And this complexity really comes to the fore in the ongoing debate about the nature of economic and social rights, ESCR themselves, doesn't it? The source outlines different views on whether they are true rights or somehow different from civil and political rights, CPR.
It does. There's one view, sometimes linked to more conservative thinking or certain governments historically, like the U.S. at times, arguing ESCR aren't true rights at all.
Just goals, aspirations.
More like desirable policy goals, aspirations, principles, rather than legally enforceable entitlements you can demand from the state.
Okay. And then there's a second view, maybe more common in legal circles, that accepts they are rights, but argues they're fundamentally different from CPR.
This view often points to the specific wording in ICSCR Article 2.1, remember that one. It obliges states to take steps towards the progressive realization of these rights to the maximum of its available resources.
Right, whereas the ICCPR for civil and political rights doesn't have that progressive realization clause. It implies immediate application for CPR.
Precisely. So proponents of this view argue ESCR requires significant resources and are not justiciable.
Justiciable, meaning courts can't really enforce them effectively.
That's the argument. How can a judge decide if the government is spending enough on housing or healthcare? It involves complex policy decisions about resource allocation, budgeting priorities, welfare programs, stuff courts supposedly lack expertise in, and that should belong to elected governments. So they're seen as unsuitable for judicial enforcement.
But the source presents a pretty strong counterargument to that view.
It does, very effectively. It points back to declarations like Tehran and Vienna, which explicitly affirm the indivisibility and interdependence of all human rights. And it really challenges the premise that only ESCR require resources.
Yeah, you mentioned this before. What about running courts?
Exactly.
So,
Isn't setting up and running a fair trial system expensive? Providing legal aid costs money. Modifying prisons to meet humane standards requires resources. So this idea that CPR are somehow cost-free while ESCR are uniquely resource-intensive, it just doesn't hold up under scrutiny.
that's a great point. A functional justice system costs a fortune.
It does. And conversely, the source notes that some ESCR are immediately realizable and don't require massive budgets. Think about the right to form a trade union, or the right to collective bargaining, or the right to equal pay for equal work.
Those are about allowing things or ensuring fairness, not necessarily huge spending programs.
Right. They're obligations to allow or ensure fairness, not necessarily provide a service costing huge sums. And furthermore, courts do make decisions involving complex policy and resource judgments all the time in environmental law, administrative law, even deciding procedural fairness.
So the argument that ESCR are only progressive and always non-justiciable, unlike CPR, which are immediate and cost-free, the source says that's a false dichotomy.
Absolutely. It's misleading. And understanding that obligation in ICR Article 2.1 properly is key. It says states undertake steps individually and through international assistance to the maximum of its available resources, progressively towards full realization, using all appropriate means, including legislation.
So it doesn't mean do nothing until you're rich.
No. It means demonstrating a committed process, taking concrete steps.
And the ICESCR monitoring body, the Committee on Economic, Social, and Cultural Rights, developed a helpful way to break down these state obligations, didn't they?
Yeah.
Moving beyond just progressive.
Yes. They adopted a really useful three-part typology: the obligation to respect, the obligation to protect, and the obligation to fulfill. Very important framework.
Okay, break those down for us. Respect.
The obligation to respect means the state must refrain from interfering with the enjoyment of the right. So the state must respect your right to housing by not arbitrarily demolishing your home or carrying out forced evictions. This is often considered an immediate obligation. Don't make things worse.
Okay, don't interfere. Protect.
The obligation to protect means the state must prevent third parties like landlords, employers, corporations from interfering with your rights. The state needs laws and enforcement to protect tenants from illegal eviction by landlords or protect workers from dangerous conditions imposed by employers.
So the state steps in to stop others violating rights. Immediate or progressive.
Sometimes immediate, but might also require progressive measures like funding labor inspectorates or courts, which needs budgets.
Got it. And the third one, fulfill.
The obligation to fulfill means the state must take positive measures to ensure the enjoyment of the right. This is often subdivided into facilitate, meaning proactively strengthening people's access and use of rights, like building schools to facilitate the right to education.
Actively helping people access things.
Right. And provide directly, meaning actually providing the right when individuals simply cannot access it themselves, like providing social housing for the homeless or food aid in a famine. This fulfill obligation is generally seen as progressive, dependent on resources.
This breakdown, respect, protect, fulfill, really shows how even rights like housing or health involve immediate obligations, like respecting non-interference and protecting people from third parties, not just long-term progressive goals.
Exactly. And the source emphasizes again, not every right or every aspect of a right in the ICSCR is solely progressive, despite that general language in Article 2.1. There are immediate obligations, like non-discrimination under Article 2.2 or equal pay under Article 7.
You can't progressively stop discriminating.
Precisely. And even for progressive rights, states must take concrete steps within a reasonably short time. They can't just sit back and do nothing indefinitely, blaming resources.
And there's also this concept of a minimum core obligation.
Yes, another important idea, although the source admits it's somewhat imprecise in practice. The concept is that even with resource constraints, there's a minimum essential level for each right that a state must strive to meet as a matter of priority.
Like a baseline survival level.
Sort of. A state is considered prima facie, on the face of it, in violation if a significant number of individuals is deprived of essential foodstuffs, of essential primary care, and of basic shelter and housing. If a state claims resource constraints in that situation, it has to prove it made every effort to use all resources to satisfy those minimum obligations as a priority. It's a high bar.
So the conclusion from the source on categorizing rights seems to be, forget neat distinctions. Human rights are complex. They demand different kinds of state action and inaction, and their meaning and application are constantly evolving. We need a nuanced understanding.
It really is. You can't just slot them into simple boxes like first, second, third gen and think you're done. It's much richer, much more complex than that.
And this complexity becomes even more pronounced when we examine how human rights interact with those powerful global economic institutions we mentioned earlier. The IMF, the World Bank, and the WTO. These are huge players, created by treaties. Main job is trade and finance.
Right. WTO regulates and pushes global trade. IMF and World Bank manage global finance, provide loans, assist developing nations. The critical question, as the source asks, is how do these institutions, with their economic focus, engage with or impact human rights? Do they help? Do they hinder?
Let's start with the World Bank, founded alongside the IMF at Bretton Woods, 1944, initially for post-war reconstruction, but quickly shifted to economic development in poorer countries.
And it's faced its share of criticism over the years, accused of maybe not providing enough aid, or even worse, contributing to the debt crisis many developing nations faced in the 1980s.
Yeah, the structural adjustment era.
Exactly. Nevertheless, its role in providing essential finance loans, credit, grants to countries that can't easily access private capital markets is undeniable. It's also been involved in major debt relief, like the HIPC initiative, heavily indebted poor countries, and signed on to global goals like the MDGs and now the SDGs.
The source mentions two main types of loans: investment loans for specific projects like that dam we talked about, or roads, schools.
Infrastructure services, yeah. And adjustment loans, which are quick dispersing funds given in exchange for government policy reforms, often focused on structural economic changes, liberalization, privatization sometimes.
Okay, but the absolutely crucial point the source highlights about the World Bank is its significant shifting stance on human rights over time.
This is huge. Crucially, since the late 1980s, the World Bank has explicitly begun to consider human rights an essential part of its development agenda. This was a real break from a previous approach that often kept economic goals and human rights concerns quite separate.
So they move from economic development first, rights maybe later, to seeing rights as integral to development itself.
Precisely. Their current view, according to the source, is that rights aren't just a desirable outcome of development. They are prerequisites and components of sustainable development. However,
There's a but.
there's often a but. Their approach is often filtered through the lens of good governance. They argue that rights can only truly flourish and be realized in countries with good governance, democratic processes, accountability, strong rule of law, lack of corruption.
And the logic is that realizing rights needs functional institutions, like courts that work, ministries that aren't corrupt.
Exactly. You can declare a right to health, but if the health ministry is riddled with corruption or courts can't enforce pollution regulations, that right is severely hampered on the ground. The bank's approach also emphasizes the interdependence and indivisibility of all rights, civil, political, and economic, social, cultural, mirroring the UDHR's position. You need progress on both fronts.
Okay, that's the World Bank. Now let's look at the International Monetary Fund, the IMF. Its purposes, laid out in Article 1 of its founding document, are primarily economic, right?
Very much so. Promoting international monetary cooperation, facilitating balanced growth of trade, leading to high employment and real income, promoting exchange stability, helping establish a multilateral payment system, providing temporary financial help for balance of payments problems.
All very technical macroeconomic stuff.
Yes, with adequate safeguards for international stability. So very focused on macroeconomic stability, exchange rates, balance of payments. Where do human rights fit into that picture?
Well, there's a potential positive link mentioned. By stabilizing economies and fostering development, the IMF can contribute to poverty reduction, which supports human dignity and economic social rights.
True, that's the positive spin. But the source is very clear that IMF interventions and the conditions often attached to its loans, the conditionality, are not always seen as an unqualified good. They can have severe negative human rights consequences.
Austerity measures.
Exactly. Think about the austerity often required. Cuts to public spending on health or education, reductions in pensions or social welfare programs. These can disproportionately and severely impact the poor, the vulnerable, marginalized groups, directly undermining their economic and social rights. We've seen this debated fiercely in many countries.
That's a powerful critique. But the source also mentions a counterpoint, that macroeconomic instability itself, like crazy high inflation or a currency collapse, is also incredibly damaging, maybe most damaging to the poor.
That's the IMF's argument, essentially. Rampant inflation wipes out savings, distorts markets, destroys jobs. They'd argue that stabilizing the macroeconomy, even if painful in the short term, is a necessary precondition for long-term growth and poverty reduction, which ultimately helps rights.
And they also link economics to better governance, similar to World Bank.
Yes, they suggest a well-managed economy, facilitated by sound policies and trade, creates an environment that supports poverty reduction and, by extension, human rights.
The source gives an example, the right to property being important for investment security.
Right. Attracting foreign investment, seen as crucial for development, often requires a predictable legal system that protects investors' property rights. The IMF sees a functioning legal system as a precondition for a good investment climate.
This leads to a related development the source touches upon, these bilateral investment treaties, or BITs.
Yes, treaties between pairs of states designed to protect foreign investments. They often allow foreign investors to bypass national courts and go straight to international arbitration if they have a dispute with the host state.
Which could be good if national courts are weak or corrupt.
That's the argument for them. They encourage needed investment in risky places by offering protection. However, the source highlights a major concern.
What's the downside?
These treaties can be used by powerful states or large multinational corporations to exploit natural resources in developing countries with little financial risk to themselves and, critically, with very little scrutiny of the human rights impacts of their operations on the ground.
Can you give that DRC example again?
Yes. The source uses the example of Chinese investment in minerals in the Democratic Republic of the Congo, DRC. DRC is resource-rich. China invests heavily, the DRC government gets payments. But the source asks, what about the human cost? Are health and safety standards met in the mines? Are local workers paid fairly? Are communities displaced by mining consulted or compensated? Is the wealth reaching the people or lost to corruption, violating their economic rights?
And the implication is often no.
The implication is that these human rights aspects are often not prioritized or even considered in these deals, and the source notes that the IMF or World Bank have limited direct leverage to enforce human rights standards in these specific bilateral deals involving private companies and other states acting outside their immediate programs.
This example is critical because it shows the actors aren't just states and the big institutions. It's multinational corporations, other powerful states acting bilaterally, private finance. They all have huge human rights impacts. It raises that tricky issue of corporate responsibility.
Exactly, the responsibility of non-state actors. The source also briefly prompts reflection on broader criticisms of the WBIMF, like in the Greek financial crisis, suggesting ongoing debates about the human costs of their policies, even if the source itself doesn't detail that specific case.
Okay. Finally, in this section, let's turn to the World Trade Organization, the WTO. It evolved from GATT, the General Agreement on Tariffs and Trade from 1947. The WTO itself was set up in 1994.
Following the big Uruguay round of negotiations, its purpose is to regulate and coordinate global trade. It manages a complex web of agreements covering everything from agriculture to banking to intellectual property. It's a forum for trade negotiations and has a strong dispute resolution system.
And its key principles: trade without discrimination, treating imports and local goods equally.
Right. Most favored nation and national treatment are key principles, and the general idea that ongoing negotiation to reduce trade barriers benefits everyone.
So the core question again, should the WTO explicitly take human rights obligations into account when making and enforcing trade rules?
This brings back that complex issue of human rights obligations on other actors, not just states, but international organizations like the WTO itself and the multinational companies whose trade it facilitates. The source notes that international human rights law, IHRL, and international trade law, ITL, are often seen as having developed largely independently, like ships passing in the night.
With not much communication between them.
Very little direct interaction or integration of norms, historically at least.
And the consequences of this separation or limited interaction can be significant and harmful to human rights.
Yes. The source gives concrete examples. The WTO's rules on intellectual property rights TRIPS agreement designed to protect patents have been heavily criticized.
For hindering access to medicines.
Exactly. Particularly during public health crises like HIV/AIDS, malaria, TB in developing countries, making life-saving treatments prohibitively expensive due to patent protection, although some flexibilities like compulsory licensing have been introduced and debated over time.
And the other example, privatization.
Yes, how privatization policies, sometimes pushed as part of trade deals or economic reforms, have made access to basic public services, schools, water, healthcare, transport harder or more expensive for the poor in some countries. This can negatively impact their quality of life and potentially undermine the legitimacy of the state providing those services.
The source points to further reading on this crucial topic of human rights and multinational corporations.
Highlighting that huge companies, think Google, Shell, Amazon, can wield economic power greater than many states. They can influence government behavior, yet they don't fit the traditional model of the state as the main rights violator.
Putting developing states in a tough spot.
Feeling pressured to attract investment, even if it means turning a blind eye to human rights impacts.
And the critical view presented in the source's summary for this section is quite stark, isn't it?
It is. It suggests the current global system of trade and finance, while often presented as good for everyone, can obscure or even facilitate the exploitation of poorer nations by richer ones and by powerful corporations. This disconnect between human rights law and economic regulation points to a systemic disharmony. Critics use strong terms like imperialism or neocolonialism, arguing the system reflects and perpetuates deep power inequalities.
It's clear that these global economic institutions, by their very design and impact, are far from neutral when it comes to human rights. They are powerful actors shaping the conditions where rights are either advanced or undermined globally.
Absolutely. And that tension continues to be a major source of debate and activism.
Okay, moving on from the major economic institutions, let's turn our attention to a concept that emerged largely from the efforts of the developing world to try and redefine this international order, putting their needs more squarely on the global agenda. The idea of a right to development.
This is a really interesting and contested concept. It challenges traditional thinking by framing development itself, not just as an economic goal or a policy outcome, but as a human right. The source looks at the arguments around this and two key initiatives that pushed it forward: the new International Economic Order, NIEO, and the formal UN Declaration on the Right to Development.
First, how should we understand development here? Is it just about GDP growth?
No, the source points to broader definitions, like Amartya Sen's idea of development as expanding human capabilities and freedoms. It includes social, political, welfare dimensions, not just economics. But then others debate whether such a broad, complex goal can realistically be framed as a legally binding right, like, say, freedom from torture. It's conceptually tricky for some.
But the source notes initiatives like the MDGs and now the SDGs showed that developing countries were successful in pushing development issues onto the international agenda.
Definitely. They significantly influence the global conversation and policy priorities, forcing development onto the agenda, even if the precise legal status of a right to it is debated.
This brings us to the new International Economic Order, the NIEO. What was that about?
The NIEO was a major political and legal push by developing nations, particularly in the 1960s and 70s. Think UNCTAD meetings, key UN General Assembly declarations in '73. It was an explicit attempt to fundamentally reshape the global economic order, which they saw as unfair and perpetuating colonial-era inequalities.
What was their philosophy based on?
Concepts like equity, sovereign equality, independence, interdependence, common interest, and cooperation among states. They wanted different rules for trade, finance, technology transfer, things that would favor developing economies.
So an ambitious project by the Global South to rewrite the rules of the game.
Hugely ambitious. And there was a real attempt to get these NIEO principles into international law. The source mentions a Soviet draft declaration on international development, pushing for equitable exchange rates, better commodity trade terms, using disarmament savings for development aid.
But the source says the NIEO ultimately failed to become binding international law.
That's right. Despite lots of discussion, working groups couldn't agree on a final text or a legally binding form. So the NIEO largely remains a set of declarations with ambiguous legal status, kind of marginal in international law today.
And why is that failure significant?
The source highlights it as evidence of the enduring power of the developed world in shaping the principles and rules of international law and the global economy. The existing powers resisted fundamental change.
However, the underlying ideas didn't just disappear. This leads us to the formal promulgation of the right to development by the UN General Assembly in 1986.
Exactly. This declaration picked up many NIEO themes, but framed them explicitly within the language of human rights. It linked development to resolving economic, social, cultural problems, promoting human rights, referencing both covenants, ICACR and ICCPR, and it had a clear political edge.
Linking it to decolonization.
Yes, linking the right to development to decolonization and people's right to self-determination.
How did the 1986 declaration actually define development?
It defined it as a broad, comprehensive process based on the active, free, meaningful participation of the entire population in economic, social, cultural, and political life. And the key outcome should be the equitable, fair distribution of the benefits arising from development.
So it echoes NIEO's equality claims, but uses rights language. And a key shift was focusing on the human person.
Yes, that was a significant difference from NIEO's more state-centric or collective focus. The Declaration states the human person is the central subject of development, bringing in that individual focus typical of human rights law.
But NIEO's influence was still clear.
Oh, yes. The Declaration talks about linking human rights to a new international economic order, reaffirms state sovereignty over natural resources, a key NIEO demand, and explicitly lists things like apartheid, colonialism, neocolonialism as massive and flagrant violations of human rights, framing political structures as barriers.
The source gives a quick overview of the first 5 articles. Article 1 calls development an inalienable human right, covers self-determination, sovereignty over resources, and the source notes this potentially allows international engagement in previously internal development matters.
Article 2 focuses on the human being as the beneficiary and participant, aiming for equitable distribution. And the source notes this implicitly raises tricky questions about whether some post-colonial states developed the necessary democratic cultures for this. Article 3 calls for international cooperation, echoing NIEO.
Article 4.
Duty to collaborate on international development plans, broadened by Article 7 to possibly include using disarmament savings. And Article 5 directly addresses obstacles like apartheid and other gross rights abuses.
So the right to development seems to challenge both developing countries to ensure participation and equity internally and developed countries to cooperate internationally and address historical inequalities. It reframes development partly around internal political issues like elite capture or weak governance.
It's definitely faced challenges regarding its legal status and how you enforce such a broad right, but it undeniably succeeded in forcing development onto the human rights agenda in a major way. And post-1986 initiatives like the MDGs and SDGs reflect this ongoing focus.
And importantly, the source highlights a crucial actor in pushing this agenda forward: civil society. The Jubilee 2000 campaign is the prime example given.
Jubilee 2000 was huge, a massive international movement largely led by civil society groups, churches, charities, NGOs advocating for canceling the debt of the poorest countries.
And they had real impact.
Absolutely. Their public campaigning and lobbying directly influenced the World Bank and IMF. Their pressure was a key factor leading to the HIPC initiative and significant debt write-offs for dozens of countries. This freed up resources in those countries for poverty reduction, health, education, concrete steps towards realizing economic and social rights that debt repayments had been blocking. It really shows the power civil society can wield.
Which provides a perfect bridge to our next section, focusing specifically on international civil society. This whole realm that's distinct from governments and international organizations, but is increasingly powerful and influential in international law and human rights protection, especially around development.
So, what exactly is international civil society? The source describes it as the international equivalent of the domestic third sector. That space that's not the state, not the market, not the family. It's primarily made up of non-governmental organizations, NGOs.
Can you give some examples of the kinds of groups we're talking about?
It's incredibly diverse. You've got professional associations, lawyers, doctors, religious groups, charities, specific advocacy groups, businesses and business associations, trade unions, all sorts. The source, citing scholars Alston and Goodman, emphasizes they're central to human rights promotion and protection. They act as watchdogs, advocates, service providers.
And the source draws some important distinctions within this NGO world.
Yes. There are nationally based NGOs operating in one country and international NGOs, INEOs, that work across borders. There's also a distinction, though sometimes blurry, between groups solely focused on human rights, like Amnesty International or Human Rights Watch.
And those with a broader focus.
Right, like Save the Children, working on children's rights and poverty, or Oxfam and Médecins Sans Frontières, Doctors Without Borders, dealing with broader humanitarian and development issues where rights are maybe one part of their work. Many development NGOs increasingly use rights-based approaches now, though.
The International Committee of the Red Cross, ICRC, is mentioned specifically.
Yes, with its broad mandate under international humanitarian law, the laws of war. The source notes the ICRC is a bit unique due to its strict commitment to formal neutrality in conflicts. That's essential for getting access to victims on all sides, but it limits their public advocacy compared to some other rights NGOs.
Now, a really crucial point the source makes, vital to remember. International civil society isn't all just good guys pushing for human rights.
This is absolutely critical. Civil society is a space where all kinds of interests get represented, and some powerful groups actively work against certain human rights developments.
Like who?
This source gives examples. Groups representing powerful multinational corporations, big oil, tobacco industry lobbies, certain pharmaceutical companies might fight hard to protect their commercial interests in ways that clash directly with environmental rights, the right to health, or access to affordable medicines. Advocacy is inherently ideological, and not all ideologies put human rights first.
So we need to be critical. Don't just accept the NGO label means they're automatically working for the universal good.
Exactly. The source stresses we need to look closely at their structures, their funding, their governance, who makes decisions, who they're accountable to, who funds them, who runs them, essential questions for evaluating their claims and impact.
To understand international civil society more deeply, the source traces the concept back to political theory, mainly looking at national civil society first. It brings in the philosopher Jürgen Habermas.
Habermas wrote about the rise of the bourgeois public sphere in 18th century Europe. This was a realm where private individuals, especially from the educated commercial classes, the bourgeoisie, came together to discuss public matters outside the direct control of the state or church.
He saw this as something new, where people engaged in the public use of their reason.
That was his phrase. It contrasted sharply with the medieval world, where politics was mostly between the monarch, nobles, and the church, without much broad public debate needed for wider economic progress or political reform.
And the growth of this public sphere accelerated in the 18th and 19th centuries. Britain is used as an example.
Yes, linked to things like the gradual extension of voting rights, like the 1832 Great Reform Act, which changed political structures. And crucially, it was fueled by better communication and transport.
Coffee houses, print media.
Coffee houses, salons, faster travel, and the explosion of print newspapers, journals, pamphlets, novels. Ideas spread fast, allowing people to form societies, associations, pressure groups, opening new ways to influence politics.
And these groups weren't afraid to challenge powerful interests. The source uses the Anti-Corn Law League as an example.
A classic example. Founded 1838, a hugely successful pressure group. They mobilized popular support against laws keeping grain prices high to benefit landowners, hurting ordinary people. Their mass agitation led to the repeal of the Corn Laws in 1846, shows the real power civil society could have. New political parties also emerged from this bubbling up of public debate.
And the source notes that even early on, these civil society groups weren't purely domestic. The Anti-Corn Law League had international trade aspects, but a clearer example is the Society for the Abolition of the Slave Trade from 1787.
Absolutely. Focus on a profoundly international human rights issue of its time, so the roots of organized public engagement, including on international matters, run deep.
How do we directly connect this concept of civil society to human rights, particularly at the national level?
Well, human rights are fundamentally part of civil society. They inform the social and political culture. In a democracy where the state serves the citizens, rights like freedom of speech, assembly, association, conscience are essential limits on state power.
The very rights needed for civil society to function.
Precisely.
Yeah.
Needed for people to organize, debate, scrutinize the state, hold it accountable. So civil society acts as a vital check on state power. If there's a strong social and political culture supporting it, a free press, public education, strong parties, a real diversity of groups. But the source highlights a critical problem. Groups who find it hard to organize refugees, people with disabilities, discriminated minorities, the very poor often get marginalized. Their voices aren't heard.
And this problem exists internationally, too.
Exactly. At the international level, where there's no single global democratic system, this lack of organization among vulnerable groups really impacts their ability to advocate effectively before international bodies dealing with human rights. If you're invisible or can't articulate your demands globally, your rights are less likely to be protected.
Now, the source calls international civil society a problematic concept in some ways. Why problematic?
Because, unlike nationally, there isn't a global state, a single global democratic culture, or one set of institutions in the same way. We have to think about it differently. The source brings in the political philosopher John Rawls and his book, The Law of Peoples.
Rawls starts with well-ordered, liberal democratic societies and tries to extend principles of justice internationally.
Right. He aims for peaceful cooperation among diverse peoples, not necessarily states, but groups with shared culture, moral nature. But he rejects a single world government.
Why reject a world government?
Drawing on Kant, he feared it would become either a global tyranny or a fragile empire constantly breaking down. Instead, he envisions a society of peoples organizing into various associations, subject to a law of democratic people's principles for cooperation, outlining duties, mutual aid. The UN is seen as maybe one example of an organization within this, having authority to condemn rights violations, maybe even intervene in severe cases.
And Rawls' Law of Peoples provides a framework consistent with civil society states, limited by rule of law, respecting rights. He outlines some key principles.
Yes, the source lists 6 principles from Rawls that echo strongly with existing international norms, like the UN Charter principles, even if practice falls short. They are: 1. Peoples are free and independent. 2. Peoples are equal and parties to their own agreements. 3. Peoples have the right of self-defense but no right to aggressive war. 4. Peoples have a duty of non-intervention. 5. Peoples are to observe treaties. 6. And crucially, peoples are to honor human rights.
So Rawls stresses human autonomy and individual rights as essential internationally, consistent with democratic societies and civil society.
Exactly. His broader concern is human flourishing, what's needed for a good life. The source notes that while specifics differ by culture, human rights focused on autonomy and respecting people's basic choices provide a necessary baseline in this diverse world.
Bringing it back to today, the source emphasizes the huge role NGOs and NGOs play in international civil society. They're more professional, organized, influential now.
Amnesty International is used as a key example of an influential INGO. Tracing its origins to 1961, Peter Benenson's appeal for Portuguese students imprisoned for toasting freedom. Amnesty's distinctive approach was focusing on civil and political rights abuses by any government, regardless of ideology, trying to be politically neutral.
And the source notes that even Amnesty's focus on civil political rights, like prisoners of conscience, is itself an ideological choice, different from focusing on poverty or housing.
Right. Their methods evolved from letter writing to sophisticated global advocacy. But credibility is key. The source mentions they sometimes make strategic choices, like maybe avoiding highly divisive issues like abortion, even if it's a rights issue, to maintain access and ability to work globally with diverse governments. Pragmatic choices for influence,
And this credibility helped Amnesty get permanent observer status at the UN.
giving them a formal voice. But despite their importance, NGOs and INEOs face criticisms. The source mentions some.
Like being co-opted.
Yes, some argue their participation in consultations with bodies like the World Bank just lends legitimacy to controversial institutions without changing much. Others criticize big Western NGOs as being elitist, undemocratic, not truly representing the communities they claim to serve, reflecting global power imbalances within civil society itself.
So they play a central, vital role, but it's complex and sometimes controversial. We need to look critically.
Their impact is huge, but yes, understanding their agendas, funding, accountability is crucial.
This dynamic nature of civil society continues to evolve, with the emergence of what are sometimes called new social movements, especially from the mid-1960s onwards.
The source highlights these were often distinct from traditional political parties or existing ideologies. It references scholar Balakrishnan Rajagopal, whose study pointed to a key feature, especially in the Third World context.
What was that key feature?
Unlike earlier national liberation movements focused mainly on politics and economics, these new movements increasingly embraced culture as a critical area for resistance and struggle.
A turn to culture. What did that mean in practice?
Emphasizing rights related to identity, land crucial for cultural survival, demands for autonomy or recognition for distinct cultural groups. These movements arose because the rights and interests they promoted, often around identity, environment, gender, marginalized communities, weren't being adequately addressed by existing states or the traditional human rights framework.
Rajagopal argued traditional rights discourse helped build states, but those states then failed to protect citizens, and rights often remained aloof from the private violence of the market.
Yes, unable to effectively tackle harm from economic actors. New social movements, NSMs, highlight these gaps. Examples include groups focused specifically on women's rights, struggles against poverty, racism, marginalization of ethnic groups.
And the indigenous peoples' rights movement is presented as a paradigm example.
Absolutely. Indigenous communities globally found their rights to land, culture, language, way of life were ignored or suppressed by states pursuing development or assimilation. They mobilized domestically and internationally, cooperated across vast differences.
And achieved real recognition.
Yes, through sustained advocacy, they achieved significant domestic legal changes in some places and international milestones like the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, shows the power of collective action by marginalized groups.
The source also notes social movements aren't always formal organizations now. Social media plays a role.
Yes, they can be more spontaneous. The hashtag #MeToo movement is given as a contemporary example of how collective action can emerge rapidly online and massively influence global discourse on rights issues like harassment and gender equality.
And the source asks us to reflect. What are the long-term implications? Is raising awareness enough, or does it need to translate into structural change?
A key question. Overall, NSMs represent a major evolution in civil society. They champion previously marginalized interests, achieve concrete changes, and also highlight the limits of traditional rights frameworks in dealing with economic impacts or collective rights. They add a vital layer of activism.
Okay, so bringing all these threads together from this deep dive into the source material, what's the big picture it paints for us?
I think the key takeaway is that human rights aren't just a separate topic over here. They are fundamentally deeply interwoven with the international legal order and the whole global political economy. They've evolved hugely
From being limited by state sovereignty.
to being seen, at least in principle, as these cross-cutting principles that should influence powerful international economic institutions like the IMF, World Bank, and WTO.
But while institutions like the World Bank say rights are part of development, there are still huge tensions and critiques about the actual impact of their policies or trade rules or investment treaties.
Absolutely. Austerity, intellectual property rules, unchecked investment, they can have severe negative human rights consequences, especially for vulnerable people in developing countries. That conflict is real.
And the ongoing debates about how we categorize rights, especially economic and social rights, and the emergence of concepts like the right to development pushed by the Global South, it shows this isn't a settled area.
Not at all. It's constantly being contested, adapted, pushed forward by different actors with different interests and visions.
And underpinning so much of this is the role of civil society in all its diverse forms, from the big NGOs like Amnesty to those newer, sometimes online social movements.
They play a central, crucial role advocating, monitoring, raising awareness, giving voice, even if, as we discussed, that role can be complex and sometimes controversial, raising questions about representation and co-option.
So understanding human rights globally really means appreciating these complex interactions, the power dynamics between states, institutions, corporations, communities, and recognizing that both state and non-state actors have roles and responsibilities. It's way beyond just rules between states.
Exactly. It's about seeing the dynamic global system, the systemic challenges, and that constant push and pull to try and make the global order more equitable and more rights respecting. It's a field that's constantly evolving.
It certainly sounds like it. So to leave you, our listeners, with something to consider, building on everything we've explored today, the power dynamics, the influence of these huge institutions and corporations, the vital role of civil society, perhaps the most pressing question is this.
Yvonne?
In our incredibly interconnected world, where power is so spread out among states, companies, institutions, movements, who ultimately holds the most responsibility for ensuring human rights are universally respected? And maybe more importantly, By what mechanisms can that responsibility actually be effectively enforced across such a complex and messy global landscape?
That is the challenging question, isn't it? Central to the future of international human rights. Definitely something worth continuing to think about as you study this area.
We truly hope this deep dive has been a valuable exploration of human rights and the international legal order, drawing on the rich insights from the material provided.
And just a reminder, this deep dive is for educational purposes, based on documents made available by the University of London and brought to you by Sinorbit Academy, Sri Lanka.
And once again, for those of you with exams coming up on this topic, the very best of luck with your preparations.
Good luck indeed. Hope this helped.